the Hall of Fame, we have a special broadcast just outside of our normal drops, and we have to talk about this. And the reason we're going to talk about this is the Supreme Court made a ruling in Montgomery versus Caribe Transport and C.H. Robinson that I've been asked in the past 2 weeks at least 20 times about it. And I sent you some articles that Freightway has wrote about it. I'm still being questioned. So I figure I'd just make a video so you guys can get an idea what this means, especially for brokers that are out there today. So this goes back for a long time. Basically, it was a Seventh Circuit has reversed the case going back to pursuing consistent opinion with Shawn Montgomery, the driver that lost his leg against Mr. I don't want to screw his name, Mojena, who veered off track with his Mack truck while hauling plastics through Illinois. The pursuit negligence of hiring this driver was passed on to C.H. Robinson. If you know how these things work, C.H. Robinson is not necessarily the broker, is not normally liable, just the carrier. So if you get a load, as I explained to this, so people understand how we got here. If you get a load from a company A, and then you're the broker, then you give it to a carrier, the carrier has insurance to the driver and so forth. The broker is just the middleman. That's how it's been for years. This decision changes that. It now says if the broker hired a subpar carrier and this carrier, Caribe Transport, had a conditional rating. Now, what does that mean? The three following ratings are satisfactory, conditional, which means that you're on the watch, not necessarily a great carrier, and there's unsatisfactory, meaning that you really can't hardly freight. So they were in a conditional rating. So they're saying, C.H. Robinson decided to give these people the load, so they should bear some of the liability around that load. So that's the basic decision. I can tell you that the U.S. government, the Department of Commerce, and FMCSA all agree that the broker should not have any skin in this game. But obviously, the lawyers themselves really wants the brokers to have skin in this game. There's a lot of reasons for that. When you talk about your average carrier in the U.S., I don't know what it is exactly. That used to be between 6 to 8 trucks. What ends up happening is that driver, that trucking company has about $1 million insurance. So if you end up killing someone, normally your payout is more than $1 million. And normally the brokers sometimes are bigger, like C.H. Robinson. They were 12. I'm going to look it up. Maybe they're a $14 billion company right now. They are the largest broker in the land. So they're saying, why can't we go after them? Because they were negligent in hiring a conditional carrier. That's the saying. I'm not saying whether I agree with it or not. That's kind of where we are. So that rule is down. So what does that mean for your brokers today? A couple of big things. One thing, I talked to an insurance provider. They said their insurance for a broker is getting ready to go up 5x, maybe 10x, because now they have liability they did not have yesterday. Now, the question I also asked an attorney, our case being litigated now, can someone go back and add on the broker to that cases? They told me they don't think so, but any new cases, you could be dragged into it. Why is that important? Because if your guy's an accident, and let's say the carrier is great, they still can name you in the lawsuit, which means you're going to get some costs automatically because now they're able to sue you because it's a Supreme Court decision. What else has it really affected? Brokers are getting really picky about who they use, and there's a huge push now with the amount of newscasts about people with illegal CDLs. I'm sure you've seen the video and the guy that turned around in Florida had a major accident. He didn't have a legal CDL. So somehow there's certain states that are popping out illegal CDLs, and that makes the broker very, very liable. So what you're seeing, and this also falling into even the foreign drivers, you're seeing a lot of foreign drivers sit because people are not taking a chance to tender them loads because they don't know for sure if their CDL is real. I don't agree with that, but I can tell you people are just being extra cautious because they're waiting for this to actually shake out to see what happens long term. Okay? So what does this mean for the truckload carriers? The truckload carriers are going to have the biggest advantage because you can go directly to them without going through a broker, which they would love because remember, the brokers are making a margin on that. So that's going to affect it quite a bit. Now, we're seeing a huge increase in brokers going out of business. And some people say it could be 30% of them. A lot of them are not going to be able to afford insurance in order to go forward. And also remember, the end of last year, the FMCSA passed a law about the bonds. Because remember, brokers were going out and paying $3,000 to get a $75,000 bond, but the bond wasn't really real. They have scrapped that. You must get the bond. You have to have the money sitting in the account or get it through a banking institution that said that you have that money sitting there, someone that's federally insured, so that if you go out of business, no one is sitting there holding the $80,000 to $75,000 worth of bills. You're able to pay the carriers and haul the loads, not just go out of business and leave everyone scrapped. So that compounded with now the increase in insurance, I think there's going to be a large closure of brokerage, which is not necessarily a bad thing for the brokers. They're doing all things right, because I think they can gain some of it. The truckload will gain some of it, the large carriers, and I think the brokers will gain some of it also. Another thing to be careful is as you go through the pick, as a broker, pick your carriers. I saw this stat, and I got it from a friend at Freightways. He told me 94% of carriers don't have a rating. I find that hard to believe. I tried to verify the email FMCSA to get out. They didn't give me an answer in time for this podcast. So take that with a grain of salt. It seemed very high to me. But that'd be very disturbing if that's the number, because how am I supposed to know if that carrier is a good carrier or not if they don't have a rating? Do I not use anyone without a rating? And that really eliminates a lot of people out there. So that's just something to think about. So I think they also need to brace themselves for what I think it's going to be a tough couple of months for brokers overall. Okay. So with that said, I just wanted to recap that to you. So remember, this is the accident. Went to the Supreme Court, and the Supreme Court was 9-0 unanimous decision. Montgomery versus Caribe Transport / C.H. Robinson. You can read up about it. I'm actually going to put the text of what happened in the bottom of the podcast, so you can kind of get a general idea what happened. In case I messed up the guy's name or anything, the text will be on the bottom of the YouTube, so you guys can see it and read it. But with that said, I wanted to get this out. I've been hounded about this in the past couple of weeks. I wrote texts, almost emails, explaining things to people. If I just put it on a podcast, everyone can access the information. You guys can get it directly from your best source for transportation, the Hall of Fame Podcast. That's our special episode. Have a blessed day.